In the last lecture, we have discussed regarding the parties which are to be sued or which may sue in a particular suit, details of which have been provided in Order 1 of the Code of Civil Procedure. Then, after you have selected the parties, plaintiffs and the defendants, and have learnt about the various rules and objections or defects which may occur in joining of the parties, then comes the second part of the suit, that is the frame of the suit, that is provided under Order 2 of the Code of Civil. As far as the frame of the suit is concerned, there is nothing has been given elaborately in Order 2 of the Code of Civil Procedure regarding the uh, frame of the suit. Now, frame of the suit has been given in the specific relief. There are various types of suits. One is a suit for recovery of the amount. One is a suit for specific performance of the agreement of sale. One is suit for regarding the inheritance of the property. So that is the frame of the suit. One is for the judgment of the tenant where the municipal laws are applicable. One is for the recovery of possession against the tenant where the rent acts are not applicable. And all other type of suits. Those are known as the frame of the suit. Now here in Code of Civil Procedure Order 2, what has been given is that so far as it is practicable, the, every suit shall be so framed to give final decision upon the subjects in the dispute and to avoid further litigation. So we have to claim the entire relief which the plaintiff is entitled against the defendant and which will avoid the further litigation. It is not that in a particular suit we can ask for one relief and then say that no, in the second suit I had not claimed the first in the first suit the relief which is being claimed in the second suit. So that is not permissible under the law. Then Rule 2 says that the suit has to include the whole relief. If there are more than one reliefs which are available to the plaintiff against a defendant in respect of a cause of action, then the suit has to include all the reliefs, but the plaintiff may relinquish any part of his claim in order to bring the suit within the jurisdiction of any court. Now, this is very important. I can give up the relief. Suppose I have to recover rupees 2 lakhs from the defendant, but the jurisdiction of the court is up to rupees 1 lakh 50,000. Then I can relinquish my relief as far as the recovery of rupees 50,000 is concerned so as to bring the suit within the jurisdiction of the court. As we had discussed in section 9 of the Code of Civil Procedure in the preceding lectures, that jurisdiction is of three types: territorial, pecuniary jurisdiction, and inherent lack. Here, the word jurisdiction means because once the legislature says the value of the suit, part of the claim, that means it is relating to the pecuniary jurisdiction of the court only. Then, if I leave or relinquish or omit to sue for the relief of rupees 50 lakhs, then subsequently I will not be able to claim that relief from the defendant. Because once I have given up the relief, the matter comes to an end as far as the recovery of rupees 50,000 is concerned. I cannot eat the cake and have it too. I cannot say that I will sue for the relief of rupees 1 lakh 50,000 and later on I will file the suit for the recovery of rupees 50,000 because Rule 2 mandates that whole of the relief has to be claimed. It is not part of the claim. Why it has been so incorporated in Constitution of India? It has been provided that no person shall be back twice for the same cause of action, for the same punishment, for the same offense. Here in 1908, when the CPC was framed, this principle was laid down by the legislature that you are to claim the entire relief and you cannot relinquish a part of the relief because the matter has to come to an end. Otherwise, there will be no litigation, no end to the litigation. It will go on continuing. I will file suit for 50,000 now, again 50,000 at the second juncture, again 50,000 for this third junction, and last 50,000 for the fourth junction. There will be multiplicity of litigation, which is not the intention of law. The courts are not free. The courts are not to be burdened with these suits. So, with this intention in mind, the legislature has said that if a part has been relinquished, then certainly no such relief can be claimed by the person against whom the same has been relinquished. So, if I want to say, so this is not an, I will clarify further that this is not the end of the matter. If I say that I want to file a suit only for the recovery of rupees 1,50,000, then whether I have any option? Yes, Rule 3 says, Rule 2, Sub Rule 3 says that I can sue for the permission of the court. I will obtain the permission of the court that I may be granted permission to file the suit for the recovery of rupees 1,50,000, and later on I may be allowed to file the suit regarding the remaining 50,000 or other reliefs. This is just a simple elaboration given by me. There may be any type of suit that I can give up one relief, but with permission I can file the second suit, and that permission has to be specifically taken by the plaintiff before the filing of the suit. At the time of filing of the suit, that look here, please grant me the relief, please grant me the permission to file the suit at a later stage, and the court in its wisdom, if it is satisfied that the cause of the plaintiff is genuine and feasible, then the court may, for the reasons to be recorded, grant him the relief. Then comes joinder of causes of action. Suppose the plaintiff has a number of causes of action against the defendant. I will give you an example. Defendant had borrowed certain sums from the defendant, plaintiff, on various occasions and had executed various per notes. Now, if he has executed 10 per notes in favor of the plaintiff and the suit has to be filed by the plaintiff against the defendant regarding all those per notes, then the plaintiff can join all the cause of actions of all the per notes in one suit, but subject to other limitations, limitation of law, limitation of cause of action, etc., etc. And if the uh, where the cause of action is united, the jurisdiction of the court as regards the suit shall be deemed to be shall depend upon the amount of the value of the aggregate subject matter of the date of the institution of the suit. Now again here the jurisdiction means pecuniary jurisdiction. If I unite 10 suits, 10 per notes for filing a suit for recovery, and the total value of the suits comes out to be rupees 1 lakh, and that is within the jurisdiction of the court, then certainly I can claim I am competent to file the suit as against all those notes against the same defendant. Then comes only certain claims to be joined for recovery of immovable property. Now, in suits for recovery of immovable property, only certain reliefs can be allowed to be joined, for as recovery of mean profits or recovery of arrears of rent. If a suit has been filed outside the limits of the municipal corporation against a tenant for the recovery of the property, then areas of rent can be claimed. And then damages for breach of contract under which the property or any part thereof is held. If there is a breach of contract under which the property was held by the defendant, then the claim for damages can be filed by the plaintiff. Then comes claim by or against the executors, administrator, or heirs. Now, here the executor, administrator, or heir is a person who is fighting the case or who is defending the case on behalf of a third person. He is not personally liable. His liability is qua the property or the value which is belonging to that person. However, if that person commits a wrong which is personal in his nature, which is very personal to his character, then certainly that can be allowed to be joined, but that too in exceptional circumstances that can be allowed to be joined. Then comes power of the court to order separate trials. If the court comes to this conclusion that joinder of various causes of action against the defendant will cause the embarrassment or delay in disposal of the case, the court may order that separate suits may be filed or the separate trials of each and every cause of action be held so that there is not a confusion in the matter and there will not be any embarrassment to the defendant. And last but not the least, objection regarding misjoinder, as we had said in Order 1, Rule 13. If there is an objection regarding the parties, then that was covered under Order 1, Rule 13. But here, if there is a objection regarding the misjoinder of the reliefs claimed against a particular defendant, then certainly that objection has to be taken at the earliest instance at the time of framing of the issues. And if no such objection is taken, then that shall be deemed to have been withdrawn. So one has to be very careful in selecting the relief frame of the suit. So you have to go through the provisions of Code of Civil Procedure very thoroughly and the provisions of Specific Relief Act, wherein various type of suits have been given. Because if the frame of the suit and the claims made in the suit are not proper, then one is going to lose the case and the entire folly, entire mistake will lie on the part of the advocate. There should not be any mistake on the part of the advocate in framing of the suit or in making the particular actions. Thank you.